Hi there, it's Richard Timpson of Richard Timpson Solicitors, and I'm here today to provide you with the next in a series of videos that I'm producing which deals with the most frequently asked questions that I get in my immigration law practice. The question I want to examine today is again a frequently asked question that I receive, and that is that I have failed in my application to the Migration Review Tribunal. It says MRT here, which is an abbreviation for that. What can I do? Now, this advice as well applies with respect to refusals or matters which have been upheld at the Refugee Review Tribunal as well, because it's the same process essentially. So in circumstances where you get a refusal decision upheld at either the MRT or the ORT, the difficulty with respect to that is that the bridging visa that you may hold, assuming you don't have any other substantive visa, will, under the operation of the regulations, cease usually within a period of 28 days after you're taken to have been notified of the relevant tribunal's decision. In those circumstances, then that sets in train a period of time through which you must leave Australia. Now, the difficulty that you have also is that in circumstances where you get a refusal and that refusal is upheld, you're still caught by the operation of a certain part of the Migration Act which prevents you from being able to apply for most visas in Australia. There are a limited number of visas that you can apply for, but they don't apply in every particular circumstances. So if you're in that situation, there are a couple of options that you can look at. One of those is potentially judicial review. However, I will deal with judicial review in another video. The one that I want to speak about today is the question of what's known as ministerial intervention. Now, under two sections that are relevant to my discussions today, there is a power in the Migration Act for the minister to consider granting a visa to someone that's had an adverse decision from one of the tribunals where it's in the public interest for him to do so, and that is colloquially known as a ministerial intervention application. Ministerial intervention applications have statistically a very low chance of success, to the region of about 20%, and much depends on who the specific minister is at the relevant time you make an application. You are entitled to remain in Australia under a bridging visa E whilst your application is being processed, and it can be, depending on your circumstances, possible to retain an ability to stay working during that time. Certainly, if you're in a situation where you're looking at making one of these applications, your application needs to be done in such a way so as to fit in with the relevant guidelines which are contained in a set of instructions that are issued to the department in that respect. If you're looking for advice in relation to that type of circumstance or situation, I would suggest that you get in touch with my office. We can be contacted at reception@richardtimpson.com.au, that's by email, or alternatively by telephone. Our Mackay number, which is 4957 4922, or alternatively on the Brisbane number 305 47144, and finally our website www.richardtimpson.com.au. Thanks for your time today.